Good morning, everyone. Happy Monday. Another week. It is now spring. Spring has sprung. And we're seeing lots of wattle and canola everywhere, and it's lovely, and the days are longer. So join Jackie Mondays at 10. Today we're talking about probate. What is probate? A lot of people have a misconception that it's some kind of tax or something that is paid when someone passes away. Probate is not compulsory. Notifications popping up. So probate only has to happen on a deceased estate if there are certain types of assets in the estate that need probate. So when there's real estate that needs to transfer, when there is cash in a bank, usually more than 70,000, sometimes if the super is being paid to the estate. So these are the main reasons. If there is water shares, that you might need probate. So what is it? It's not a tax, and it is different in every state. So depending on which state the person passes away in is the state where probate is granted. An application has to be made by the executor to the Supreme Court of that state. Basically, what the executor is applying for is an endorsement from the Supreme Court that the will is valid and that they, as the executor, are allowed to do what they're supposed to do as executor. That it's a yes, here's the will, yes, you've been granted the authority to do what you need to do. And so the grant used to be this lovely piece of parchment, which felt like it had some legal weight. Now it's just a PDF that gets emailed out. And no, it doesn't. There is no death taxes in Australia at this point. The fee is a sliding scale court fee. In Victoria, the fees are fairly low. Usually it's between $60 and $600. Sometimes it's up around $2,000 if the estate is millions and millions of dollars. But otherwise, most estates are between $60 and $600. Other states, the fee scale is vastly different. New South Wales is very expensive, but still it's not a tax. It's just a sliding scale. So that is probate. It is separate from what the legal requirements are for an executor, their obligations and duties, because an executor has those obligations and duties whether or not probate is required. Probate does give the estate some more formal legal life about it, so to speak. There are certain timeframes that run once probate is granted. Creditors can also apply for probate if the estate is insolvent and no one wants to come forward and administer the estate. A creditor can do it so they can recover what they need, and then the estate can become insolvent. And while we call it probate, there are a couple of different versions as well. It's called a grant of representation, and there is probate, or there's letters of administration as well, depending on whether it's the executor actually applying or whether it's someone else applying, or whether there's some variation made to the will. Letters of administration gives the same legal effect as a grant of probate once it's granted. So I hope that provides some clarity. What we try and do when we do the estate planning process is try to minimize the chance that probate is required, particularly between spouses, but sometimes it is. And as I said, it's not such a financial burden. It can be a bit of a time burden, particularly if it's not a smooth application, if there are requisitions that the court raises as to questions about the will or questions about the capacity of the will maker. But these are all things that we help the executor to address. So have a great week. I'll catch you again next Monday. If you feel like this topic was useful for someone you may know, please tag their name in the comments underneath. or you can share it with them via Messenger, which is a bit more private. This video, while live, will get saved onto the page and go into the massive library of videos that we now have on this page, which is a great resource to start. If you need to find something, start there. But otherwise, you can contact us for more questions, email, phone. Have a great week. Happy spring.